Good afternoon. Welcome to this division of the Court of Appeals. We have two cases on the docket. I see counsel are here and ready for the first case, which is People versus Jones. And then we have Town of Monument versus the state of Colorado. I know that we have two experienced counsel here, but let me just remind you, particularly relevant for this case, we're live streaming, so just be aware that whatever you say will go out over the internet, and I think there's victim names that shouldn't be said on the live stream. Also, Mr. Sheehan, you have rebuttal time, but you'll have to manage your own clock for that. You can just let us know when you're ready to sit down and come back up for a rebuttal. Any questions from counsel about our policies?
Well, only one, Your Honor. The comment you just made a minute ago about the live stream, I assume that you're referring to the witness that will be referred to as KP.
Correct.
In our argument, but not anybody else in our case.
I'm not aware of anybody else.
Okay, thank you.
Sure. And then when you're ready, Mr. Sheehan, we're ready to go.
Good afternoon. And may it please the court, my name is Michael Sheehan. I'm the attorney for the appellant Gregory Jones. I'd like to begin my argument by discussing the Rule 602 issue in this case. And the reason that the reason that issue is important in this case is because it turned what should have been what I'll call a he said, she said trial into a he said, they said trial. And what I mean by that is the alleged victim in the case, KP, accused my client of a sex assault. My client, Mr. Jones, admitted that he had sex with KP, but asserted that it was consensual. The big fact in this case that called into question my client's claim that it was consensual sex was the fact that KP had a black eye. My client asserted that somebody else, most likely witness Barry Schilling, caused the black eye. It was Mr. Schilling that was allowed to testify in violation of 602 that KP was being raped. And that's what caused the big problem in this case. The evidence that was tendered to the court prior to the start of trial was that Mr. Schilling had been sort of tricked into getting out of a vehicle that my client, Mr. Jones, was driving, and was left standing on the side of the road while my client drove away with KP. It's prior to being tricked into getting out of the car, Schilling told a 911 operator and testified during the trial that he was being given a ride home by Mr. Jones, and that at one point, prior to getting out of the vehicle, he saw Mr. Jones putting his leg on KP's leg. Saw Mr. Jones putting his hand on KP's leg. That's all he saw prior to being tricked into getting out of the vehicle. From that, he called 911 and said, KP's getting raped. This is 5 minutes or so after he got out of the vehicle, but he reported KP's getting raped. KP's getting raped. He said it numerous times. The evidence was manifestly insufficient for him to give that opinion. That's all it was. It was speculation. It was an idea that he had come up with that was not grounded in the evidence or what he had observed up to that point. And it was something that we identified far in advance of the trial as a problem because, as I said, it was going to be used by the government to corroborate what KP was going to say at trial, but there was not enough foundation that's required by 602 for him to say that.
But Mr. Sheehan, can I just ask about the prejudice to the admission of the tape? I mean, it's obvious even from the recorded call itself that he doesn't know, he doesn't have any basis for saying it. And the jury would have known, and frankly, the court essentially instructed the jury that it's not based on his personal knowledge. So I'm trying to understand how that would have been prejudicial to Mr. Jones.
Your Honor, the problem with that is that the way that the court instructed the jury gave the jurors the impression that even though it might have been what was in Mr. Schilling's mind or what he believed, the jury was left to assume, based on that instruction, that what Mr. Schilling believed was somehow relevant to the case, that it strengthened or bolstered the government's arguments in favor of convicting Mr. Jones. That's why we objected under 401 and 403 prior to the court determining that it was going to give that limiting instruction, because even with the instruction, the jurors would have been confused about what amount or what type of weight to give to that particular evidence. And it was important enough to the government that they used it in closing argument, as I pointed out in my brief. They went so far as to characterize it as wonderful, I'm using quotes around that, wonderful evidence. So it was certainly something that the government keyed on as corroborative of what KP had said in her testimony. And the reason that it's not insignificant to the case, Your Honor, is because this case was, despite the fact that that evidence was admitted, it was a close call. The jury was out deliberating for 2.5 days on the case. It's a case where KP was impeached by a neighbor that had known her for 25 years, who testified pursuant to Rule 608 about KP's character for untruthfulness. KP was impeached by her own felony conviction. KP's testimony was inconsistent with itself and inconsistent with prior statements that KP had made. KP had a motive to make this up. There was testimony that Mr. Jones refused to drive her home after this, what he describes as consensual sex with her. She was going back to Mr. Schilling. She needed some kind of story to tell him about where she had been and what she had been doing. Both Schilling and KP were intoxicated. Both Schilling and KP admitted that they were arguing and fighting prior to going to the Metro bar where they met Mr. Jones. I bring this all up again during the oral argument just to make the point that this was not a situation where this was an open shut, slam dunk case for the government. It was anything but that, even with what we argue is the impermissible 602 evidence in this case. I now want to turn my attention to the second issue in the case. In my opening brief, I'm listed as issue 2 and issue 3, but I'm going to try and argue it here today as really one issue and try and encompass everything I'm trying to say about it. And this is the issue dealing with the habitual trial in this case. The habitual trial was set one afternoon. The witnesses that were called by the government consisted of a district attorney's office investigator and a witness that was endorsed as an expert named Diane Page. The court can see from the record that Ms. Page came to the hearing unprepared. The work that she had done was done that morning, and throughout the cross-examination, it was clear that she had no real methodology to what she was doing. The court had concerns about her qualifications as an expert and made the comment more than once that Ms. Page was unprepared. Toward the end of the testimony that day, Jones objected to her qualifications. The court sustained the objection, but the court, sua sponte, set the case over for more than 30 days and explicitly stated on the record that she was doing so in order to let Ms. Page get more prepared. Jones objected at that point and objected again when the hearing resumed over 30 days later. Counsel for the government is correct that Jones did not explicitly cite to statute 18.1.3803 section 1 during that objection. But the basis for the objection at that point was what had happened was Jones's cross-examination of Page during the first part of the habitual trial was essentially going to be used like a deposition by the government, who was going to go back to the drawing board with Ms. Page in the interim 30 days, 39 days I think it was, and fix the mistakes and plug the holes in her testimony and have her come back and do the whole thing over again. So when it comes to preservation of that issue, it's true that Jones didn't specifically cite to 18.1.38031, but was objecting to the fundamental fairness of what was happening. And I think that the as soon as is practicable language from 18.1.38031 is trying to get at the same issue, that there's got to be some safeguards in place and some sort of critical analysis of how this habitual trial is going to be conducted in order to protect Mr. Jones's due process rights. Because what Jones was concerned of at the end of the first part of the hearing is exactly what happened. And Ms. Page came back for the second part of the hearing, cleaned up her testimony, and the judge adjudicated Mr. Jones a habitual offender.
Mr. Sheehan, can I just ask a quick question about
Yes.
preservation of this? Because you have a number of reasons why you think there was an error related to the continuance. One of them is, I think, that there's been a violation of the statute that says you must have the hearing as soon as practicable, or whatever the language is. As to that particular issue, are you saying that that was preserved by your objection, that there shouldn't be a do-over of the witness's testimony?
I'm saying that it is, Your Honor.
Okay.
I'll concede that I didn't specifically cite to the statute number, but my argument is that it was preserved under the statute.
But in terms of the timing and whether or not this needs to be, the hearing has to be held quickly after the jury verdict, I thought, if I'm recalling correctly, the court even asked a question about, is there any time constraint? Am I under any time constraint? And the defense counsel, and I can't remember if that was you or not, I apologize, said, no, there's not. There's no time constraint. What I'm concerned about here is not that. What I'm concerned about is I don't think it's fair for there to be a do-over. So that sounds like it's not just unpreserved, but really kind of leading the court down a different path.
I understand your question, and I was the trial attorney on the
Okay.
case. The question the judge asked was, is there a speedy trial provision that you can cite to? I think that's what you're referring to. And I told her, no, there's no speedy trial right when it comes to this habitual trial. When I cite back to the as soon as is practicable language, Your Honor, I think that that language encompasses not only how far out the habitual trial gets set from the jury verdict, but how that habitual trial is conducted. In other words, I think that when the trial gets broken into two different pieces separated by 39 days in between, that violates the as soon as is practicable language in the statute. I hope that answers your
Okay.
question.
Counsel, on this issue, does the statute say that the remedy for any violation of the statute is dismissal of the habitual criminal charges? If not, what's the authority for imposing that remedy?
Your Honor, the statute does not specifically say that. I cite to the Colorado and federal Constitution due process clause in support of this argument, because as anybody who is involved in these hearings knows, that the habitual trial is every bit, if not more important to the case as a whole than the jury trial. And this case is an example of that. The charges are serious, obviously, kidnapping and sex assault, but they go from serious to what amounts to a life sentence if the government can prove the prior convictions beyond a reasonable doubt. So the due process clauses of both constitutions ensure that are designed to ensure that the judge presides over these hearings with a critical eye, and if the government doesn't come in prepared to prove the case beyond a reasonable doubt, they shouldn't be granted that kind of leeway.
Well,
because
counsel, I want to focus in on the remedy again. I know you're arguing due process, I get that, but it seems to me you're also arguing the statute, and I don't think they're the same thing. In other words, you could have a statutory violation without having a due process violation. So unless there's a constitutional violation and there's only a statutory violation, how do we get to a remedy of dismissal? That is, no due process violation because the time isn't so great that it amounts to a violation of due process, but it is great enough that we determine it wasn't as soon as practicable under the statute.
I think I understand your question, Your Honor, and I would say that really the part of the problem that I haven't touched on very succinctly up to this point is the confrontation problem. In other words, the witness was given a preview of every single question I intended to ask her on cross-examination, and the government took it back with them in the 39 days in between the first part of the hearing and the second part of the hearing, and eviscerated Mr. Jones's opportunity for an effective cross-examination. And I'm going to ask to reserve the remaining 50 seconds that I have for rebuttal, please.
Okay.
Excuse me. May it please the court, my name is Jacob Lofgren, registration number 40904, and I represent the appellee, the people of the state of Colorado. The people respectfully request that this court affirm the district court's judgment of conviction for 3 reasons. First, the victim's boyfriend's statements in the 911 call were properly admitted at trial. Second, the court did not err, let alone commit plain error, when it continued the habitual trial for 39 days. And third, the court did not err, let alone commit plain error, when it allowed the prosecution to recall a witness after that continuance. As to the first issue, the court here did properly admit the boyfriend's 911 call under CRE 701 and 602. The threshold for satisfying that personal knowledge requirement under 602 is not very high. The Supreme Court of Colorado has made that very clear. And in order to meet that threshold, you can look at the circumstances surrounding the statement. What that means is that context is critical. And in this case, that's abundantly clear that context is critical. What we had here was a witness who testified as to the step-by-step that happened before his 911 call. He was at a bar with his girlfriend. They got a ride home with another gentleman. That gentleman dropped his cousin off at his house. They went to a 7-Eleven. The victim got in the front seat with the defendant who was driving. The defendant immediately started to touch her leg, touch her shoulder, engage in unwanted touching. Mr. Schilling, the boyfriend, says, "Stop, you shouldn't be doing that." A fight is about to ensue. The defendant says to Mr. Schilling, "Hey, let's get out of the car. You want to handle this like men kind of thing?" Mr. Schilling says, "Sure, let's do it." They pull over, Mr. Schilling gets out, defendant takes off. That's when the 911 call occurs. After this touching, after all of these incidents that suggest something bad is about to happen here, and Mr. Schilling at that point makes a panicked 911 call where he says, "Oh my gosh, here is everything that just happened. I'm afraid my girlfriend is about to get raped." He's not saying, "I know she's getting raped. I see her getting raped." He's not making any statement of fact. He's making a contextual observation based on what he saw happening in the car.
Mr. Lofgren, I thought that in the tape he says, "She's getting raped right now." That's what he tells the dispatch.
He does use those words. And what I think I'm trying to point out is it's clear from the context and from what the jury heard, especially in light of the limiting instruction, that he's not making a factual observation when he says that. That's his fear. That's his concern based on what he saw prior to the defendant taking off.
How is that relevant, though? How is his concern relevant to any issue in the case?
It's relevant in this case for one critical reason, and it's the defendant's theory that he presented is this was consensual and Mr. Schilling just got out of the car because he wanted to. All of this testimony and the 911 call defeats that theory. The panic in Mr. Schilling's voice indicates that this wasn't him just getting out of the car because his girlfriend wanted to go away consensually with the defendant.
But that point could be made without any of this other stuff about KP is getting raped. He's raping her right now as we're talking. KP just got raped. These are guesses, total speculation. They don't show, it seems to me, anything relevant about what was actually happening.
I agree that point could have been made without the 911 call, but the question here is, was it an abuse of discretion to also allow the 911 call in? And I don't think it was. All the 911 call did was add to that testimony by showing the panic that was being described prior to its admission. Even if this court disagrees and thinks that it shouldn't have been admitted, any error here had to be harmless for 3 reasons, and the 3 reasons I outlined in my brief. The first is there were repeated limiting instructions. I think 4 times during the relatively brief testimony of Mr. Schilling, the court instructed the jury, this is not being admitted as a statement of fact, it's being admitted to show his state of mind. So the jury was well aware that this statement, this 911 call was not being admitted to prove that KP was being raped or to prove that Mr. Schilling saw that. The second reason this would be harmless is because there was ample other evidence to demonstrate non-consensual sex occurred in this case. Particularly, there were photographs and the same nurse's testimony concerning the injuries that the victim sustained. Numerous people testified throughout the trial the victim had no injuries before she was taken away by the defendant when he sped off in his car. Most notably, the defendant's own witness, his cousin, said there were no injuries on KP before the car sped away, or when I last saw her when I got dropped off at my house, I should say. And the third reason is that, excuse me, lost my place here. Oh, the third reason was the cousin's testimony. The second reason was the photographs of the injuries. So if the court has no other questions about 602, I will move on to the habitual issue. Here there was no error, let alone plain error, in continuing the habitual trial for 39 days. The defendant spent some of his time here today suggesting that his fair trial objection was enough to preserve this issue, and that simply can't be the case. When you have an objection or an issue like the defendant is attempting to raise on this appeal that relies on specific statutory language, simply saying, I object, I have a right to a fair trial is not enough to alert the district court that it should be looking at a statute, let alone deciding what that statute means and how it applies in this case. Simply put, the objection here was not enough to preserve the issue the defendant raises on appeal. And for that reason, I would point this court's direction to the Valencia case, which I cited in my brief. It's a case from this court that dealt with facts incredibly similar to those presented on this appeal. In that case, the district court granted a continuance to allow the prosecution to remedy some defects with pin packs that it attempted to introduce at trial. The court found there were some technical issues and said, let me give you some more time to figure that out, fix it. On appeal, the defendant, just like here, tried to raise for the first time that as soon as practicable language, and the division of this court said, no go. You didn't raise that language below. We're not going to rely on it here to find a violation. There is no case interpreting that language such that we could find a violation, and certainly not under plain error. The other thing I would point out about Valencia is, in that case, there was actually, I think, 3 or 4 month delay between the initial habitual hearing and the second part of it. And even there, the division found no plain error in that amount of continuance. Here we have roughly a month. It was a short continuance, fairly standard on a court's calendar, granted partially at the request of the defense to get more discovery in order to address some of the concerns that were being raised at the first part of the habitual trial. And the last thing I would point out as to why there can't be plain error is when the second date was offered for the continued part of the habitual trial, the defendant did not object. He never indicated that's too far away. He never said that's too much of a continuance. He made no indication that a 39-day continuance was unfair or unreasonable. And the last thing I'll note with regard to the habitual trial, because it came up during defense counsel's presentation, is the confrontation issue here. The defendant was given a full opportunity to cross-examine Mrs. Page at the first part of the habitual trial and at the second part of the habitual trial. And he cites no authority for the concept that because she was able to fix some of the defects in her testimony, that he was somehow deprived of his right to confrontation.
But I mean, I think that Mr. Jones's argument is that seemed like a fundamentally unfair process, that the prosecution comes in, it has a witness who can't get the evidence in, who is not persuasive. I think the court says that the witness is not persuasive. And then the court says, well, you know, prosecution, why don't you take a break, get your witness prepped, and come back in so you can prove up the habitual charges. I think the crux of the argument is that seems kind of unfair.
I think that is the argument, but I would step back and say I don't think that's one entirely accurate depiction of the record. I think what happened here is Ms. Page is testifying, and the court certainly expresses some dissatisfaction with what she is testifying to, and the prosecution, recognizing that dissatisfaction, tries to walk her through. Let me step back. The issue that was causing the confusion was she was saying, I didn't take notes identifying how I matched fingerprint A to fingerprint B. The court was dissatisfied with that. So the prosecution said, well, then let's do it here in court. I'll give you the pen pack. I'll give you his sample. Compare them in court for the court. The defendant at that point said, no, that's not fair. I haven't had any discovery of this. I haven't seen any notes. I haven't seen anything that supports what she is about to testify to. At that point, the district court says, fair point, let's continue this so that she can get more prepared and you can get the discovery to match what she is about to testify to. I don't think that that's necessarily an indication that the prosecution's witness was unprepared. More so, it's an indication that the district court got confused, wanted something more than the prosecution had brought with it, and when the prosecution tried to remedy it, the defendant objected. That's what led to this continuance. And it's a number of factors, but that's really what prompted the district court to say, let's put this off for another day. And if there are no other questions, I would ask this court to affirm. Thank you.
Just a couple of quick points in my remaining time. The objection at the end of the first part of the habitual trial was not just, I have a right to a fair trial. The objection stated concerns about the prosecution hearing all the cross-examination questions and getting a chance to fix them. It was more specific than just this general fair trial objection. And also, this was not a situation where there was a continuance sought by Jones in order to get more discovery. Jones wanted the evidence to be closed that afternoon and go straight into argument. The objection at the time when Ms. Page and the district attorneys proposed this idea of a live in the courtroom side-by-side comparison was that we're entitled to discovery. Even in the habitual phase of a case, we hadn't received any such discovery. The sanction that we would have wanted to see happen that day was close the evidence, go into argument, not continue. It was not a request by Jones to continue the case in order to make a discovery request.
Okay, and Mr. Sheen, your time's up, but before you sit down, I think I understand the crux of your argument. What I am wondering is if there's any authority to support the argument that the court should not have just sua sponte sort of tipped. It sounded to me from your briefing, like what you were saying was this is sort of unfair. The court sua sponte kind of tipped the balance a little bit for the prosecution. Is there any authority for saying that the court could not do what it did?
When you say do what it did, if I understand what you're asking, Your Honor, you're saying that the court, well, you're not saying this. You're asking me what prevents the trial court from stopping a habitual trial and saying to the government, go prep your witness better and come back and see me.
Right. Do you have any case law that says the court cannot do that? You cited a case, but that case says the court can do it. So is there any case that says that the court can't do it?
Your Honor, as I stand here right now, I don't have a case name for you to cite. I would just, again, cite back to basic principles of fundamental fairness in not only jury trials, but also habitual offender trials.
Okay, thank you. Thank you to both counsel for your excellent arguments. The case is submitted. We'll issue an opinion in due course. And counsel, I think you were both here when I made a couple of announcements before the last case, but if you have any questions, now is the time to ask. No? Okay, again, I'll just emphasize that you can save time for rebuttal as well as you can manage the clock. That's up to you. So we are ready to go in the Town of Monument case whenever you're ready.
May it please the court. My name is Joseph Rivera, and our firm Murray, Dahl, Kiekenmeister, Renault represent the Town of Monument in this matter. The trial court and the appellees disregarded the principal lesson of the Supreme Court's decision in Smith v. Clifton. And that principal lesson is a restrictive covenant may create an enforceable right against all, except a condemning authority exercising the power of eminent domain for a valid public purpose. And Steamboat v. Johnson did nothing to change this lesson. The key to this case is the identification of the property interests at issue. The restrictive covenant in Smith v. Clifton is almost identical to the restrictive covenant that's at issue before the court. It is a recorded covenant, a promise among landowners to impose a use restriction. There is no independent or distinct servient or dominant estate. There's no use right. There's no right to enter the property of another. It's basically a negative. It's a right to prohibit the use of land of others for a specific purpose. And like Smith v. Clifton, the Town of Monument did not take any actual property. They did not take any 1 inch of actual personal property from any of the beneficiaries of the Forest Valley Covenant. In Steamboat, it's much different. How is it different? When Steamboat, the Town of Steamboat condemned portions of an independent and distinct servient and dominant estate. In Steamboat, there was a planned unit development, and that planned unit development had as a boundary a greenbelt. And the city of Steamboat condemned a portion of one of the lots in that development and a portion of the greenbelt. It took actual inches, portions of real property from both the dominant and servient estate. Moreover, there was a easement relationship between the dominant and servient estate. What was that relationship? The greenbelt existed for the benefit of the lots. This was a planned unit development that had as an amenity in its property records green space. There were other people. That green space was also available to the public, but there was a legal deeded right to that greenbelt use afforded to the owners of property within that development. The other, I think, issue that I'd like to point out is that the appellees relied too much on Steamboat for its interpretation of Smith v. Clifton. There's some language in Steamboat that basically stands for the proposition, or it states, Clifton The phrase is, Clifton does not stand for the proposition that recorded covenants or negative easements are never compensable interests. It is true, there is that phrase within that language. However, what the appellees did is they turned that phrase on its head and made it stand for the proposition that recorded covenant interests are always compensable, and they're not. Again, the most important part of this case is the definition of the property rights at issue. And there's a level of specificity that I'd like to alert this panel to that's important in understanding the property rights at issue. At the most abstract level, or the most general level, there are servitudes. And there's plenty of case law out there that basically says servitudes are protected rights. They're enforceable rights. Then, below the category of servitudes, there are two subcategories: easements and restrictive covenants. However, those are two very different types of property interests. Easement interests have a dominant and a servient independent parcel. For example, a dominant parcel may use an adjacent parcel so that they could get to the main road. It's two independent property interests that rely upon each other for a goal, and with one serving the other. Restrictive covenants have no independent or distinct servient or dominant interest. At the Forest View Estates, basically all of the properties, all 54 of the beneficiaries, are both dominant and servient to one another, in essence.
Counsel, I'm sorry, can I interrupt you for a moment? I actually was struggling with the extent to which you, the appellee, and then the court believe that Steamboat really had any significant role to play in resolving the case before us, because it seems to me in Steamboat, they were really interested in what type of property interest this was, mainly for purposes of deciding how to value the property that had been taken. They weren't really arguing about whether this was a compensable property interest. That seemed to be conceded and agreed to by all the parties. So the mention of Smith in the case really doesn't seem to be significant, as far as I can tell, in terms of how we would use Steamboat to resolve the issue before us in this case. Can you help me understand why this seems to be viewed as such a significant case for how we resolve this case?
What I hear the court saying is that how does Steamboat help solve this case? And my response would be, it doesn't, because it has a completely different property interest at issue. It's a dominant and servient estate as opposed to a restrictive covenant. And Smith v. Clifton is very clear that restrictive covenants are not compensable in condemnation actions. That is very clear. The issue in Steamboat, as I understand, is the valuation of the taking. And why Steamboat is different and not instructive in resolving the case before us is that it was a completely different property interest. And that's why it's important to think about it in terms of dominant and servient estate. So because, as I mentioned, the city of Steamboat took portions of the dominant estate, the lot in the subdivision, as well as portions of the greenbelt, there were two property interests that had to be valued for the purposes of condemnation, for the purposes of determining just compensation for the take. The parties in Steamboat actually stipulated that, to the fact that the condemnation of the dominant parcel, the portion of the actual lot in the subdivision, was compensable, and they actually stipulated to a value. Steamboat was mostly concerned about how to value the easement interest, the servient interest. And what it decided was essentially that it relied on a benchmark valuation of condemnation cases, which is the impact on the fair market value. And what it basically said, and the court instructed, or remanded the case back to the trial court for the purpose of conducting the required analysis to determine how the taking of the servient estate, the greenbelt impacted the value of the dominant estate, the lot. So, did the lot, the lot in the subdivision, lose some value because some of the greenbelt was taken away in the eyes of the market? We have, and back to the point that I started with, none of that matters to this case because there's no actual property taken, it's not an easement interest, and there was no, it just doesn't apply. And what does apply to this case are the policy, are the categorization of the property interest as a restrictive covenant, which doesn't have any of the components or characteristics of a easement interest, and the policy decisions and policy reasons offered by the Smith v. Clifton Court for why it's unwise and bad public policy to consider restrictive covenant interests as compensable interest in a condemnation action.
Counsel, but didn't the division in the Johnson case say that Smith was limited to its peculiar facts, those being that there had been this concerted effort by the landowners in the area to thwart a condemnation that they saw coming down the road?
I think there's two responses to that. I think that Clifton has a broader reading than that, and I would suggest to this panel that the Clifton court saw mischief anywhere a restrictive covenant had a compensable interest. And I think if you accept that logic, it creates problems down the road. Let me explain. So, for example, major public projects take lots of time to go through. I-70 is a great example. So we knew 10 years ago that I-70 was going to be expanded. If the residents of Globeville had decided at that point to enter into this covenant and basically somehow protect that land adjacent to I-70 and cause some type of compensation or try to create some kind of compensable interest for all this whole area based on the taking of that land immediately adjacent to I-70, if they did it 10 years ago, and 10 years has passed, then you don't have this notion of a scheme, an imminent scheme. But it still has the same impact. Or so you have this question of how to determine this temporal proximity, which is, I think, which the court, I think, understands very clearly that creating or accepting this notion of a restrictive covenant as a compensable interest just gives rise to the potential of abuse at every stage. And I don't think that they attempted to. And if you read if you read Clifton as I read it, I don't think that these public policy arguments were placed in that context.
All right, so my question, though, was more of what Johnson said about Smith.
Okay.
So it seems to me you're saying, if I can read between the lines, if it said that, it was wrong. If it said that Smith, or Clifton as you refer to it, is limited to its peculiar facts, that's wrong.
I think what it said was that the language that I think is the most operative language is the language in Johnson that said that restrictive covenants are, Smith doesn't stand for the proposition that restrictive covenants are never compensable interests. And that's true, and that can be true. And what the Johnson court, or the Steamboat court said is that this is a particular variety of an easement interest that is compensable. So it created this distinction. And that's why I put so much emphasis in categorizing the property rights at issue. And to try to circle back is that the issue is, in Smith v. Clifton, there was no actual property taken. In Johnson, there was property taken from a traditional easement from both the servient and dominant estate. If the panel doesn't have any further questions, I'd like to reserve the remainder of my time for rebuttal.
Okay.
May it please the court, my name is Ed Hamrick, registration number 24586, and I'm here representing the State Board of Land Commissioners. At council's table is also Brenda Bartels, who's representing Forest View and the private property owners in this matter. Currently, we anticipate that I will be addressing all questions, but perhaps, if appropriate, I'll step aside to allow Forest View Company and the private property owners to be able to have an opportunity to address some of these issues. Fundamentally, in this case, the town seeks to condemn property rights that it acknowledges it does not own without compensating the property owners. And I want to talk to those core issues and the issues that council raised at argument, but briefly I want to touch on the jurisdiction issues that the state raised in its brief. There are two orders on appeal here. There is a July 6th order in which the district court determined the governing law that would apply in the condemnation case. And then there is the July 29th order granting a stipulated dismissal of this case with prejudice. The July 6th order is not a final order. Again, it was merely determining a legal framework that would apply in the case, essentially whether the restrictive covenant interest that the state and the private property owners owned was a compensable property interest, and it acknowledged that it was. But it did not enter judgment or resolve all issues in the case, and therefore it was not ripe for appeal. On the other hand, there's the order granting the stipulated motion to dismiss this case with prejudice. That is a final appealable order. However, the town has not presented any reasons or rationale for setting aside an order that it requested, and all the parties requested, the district court issue in this case. Essentially, the parties attempted to manufacture a finality in this case that wasn't procedurally established.
Counsel, but that happens all the time. I mean, 54B expressly allows it. A party can request that a particular order be designated as final, and it's then appealable, and we don't say, well, you asked for it, so it's not appealable. We don't do that.
That's exactly our point. 54B provides a remedy, and there are standards which the trial court has to find. And then, as in Allison v. Ingalls, the Court of Appeals looks at those trial court findings. They don't just accept them, and they don't accept when the parties stipulate to them.
But those findings relate to not finality so much, but why should this case proceed on appeal at this particular juncture? We don't have any of that here. It's final, the case is over in its entirety. If I'm just troubled by this notion that you can do something by 54B, but you can't do it as to a final judgment. You can't ask for a final judgment so that you can move on to the appeal.
54B has its own standards to be met, including requiring the court to make findings. There was not that request. Those standards were not met. The court did not make those findings. This court doesn't have the ability to review whether 54B is met. So 54B I don't believe applies. There's also an ability to request for an interlocutory appeal under CAR 4.2, and it has its own standards to be met. That request was not made, those findings were not made, and those standards were not established. Here, in effect, the parties have stipulated to bring the matter to the Court of Appeals, which under the Allison analysis, at least under the 54B context, the parties can't stipulate.
But that's not really what's going on. What's going on is the town is not going to proceed with the case because of the ruling. So I suppose they could have gone about it somewhat differently, but the result would have been the same. The case would have been over.
2 points to address that, I believe, is yes, the town made a decision not to proceed with the case under the determination of the operable law, but that's a town decision based on weighing litigation priorities and resources. That's not a procedural gateway to automatic jurisdiction with the Court of Appeals. In addition, the other side of that is the case is over. It is now resolved. There's no case left. Even if the court were to accept the town's characterization of the law and change the July 6th order on the substantive law, the case is still over. The town no longer, because the case has been dismissed with prejudice, cannot start a new condemnation action.
I'm confused, counsel. We see appeals every day from cases that have been dismissed with prejudice. We see them every day. That's standard. So that fact can't mean we don't have jurisdiction.
Well, this is, again, a stipulated dismissal with prejudice. And while I understand that there are other cases, that there are other procedural elements, and I appreciate the point, I think here, where the parties have asked for the case to be to be dismissed with prejudice, not asked for that order to be overturned, because there is not anything in the town's brief that says that the order dismissing the case with prejudice should be overturned, nor does it give, it doesn't ask, nor does it provide any rationale for overturning that order.
Counsel, can I follow up on that a little bit then?
Sure.
So, assuming we set the jurisdictional issue aside for now, so why are all of you here? What's the impact of what it is we're deciding?
Well, I'm not entirely sure I understand your question, Your Honor.
Well, I think you were saying that the
ultimately,
case is done, the case has been dismissed with prejudice. So if we agree with you or we agree with Monument, what's the impact of our decision in this case?
I think the impact of the decision is the town of Monument's no longer able to bring the condemnation. Ultimately, we're here to protect the property interest of, on behalf of the State Land Board, the School Lands Trust, and on behalf of the property owners, their individual property interest. But ultimately, I don't believe that if the court were to set aside the July 6th decision, that will allow the town to refile its condemnation case. And since they haven't asked for the dismissal to be set aside or provided grounds for setting aside the dismissal that the parties asked for, that order isn't available to be set aside.
So,
So
what are we doing?
So ultimately, I think the case is moot. And I think that's why the court lacks jurisdiction here.
I'm also a little concerned about the record showing that your client expressly agreed to the dismissal with prejudice for the express purpose of allowing an appeal.
It's true, and if the court finds jurisdiction, we are happy to address the substance of the discussion, and I hope to have an opportunity to move on to that. I don't want to pretend that the parties didn't intend to bring this matter to the Court of Appeals, or that there was any type of gotcha played upon any of the parties. Certainly when we were discussing the appeal and how to bring it before, the concern of how to address the issues of 54B and the Allison case were discussed. It was felt that this was a way that what the parties chose, the stipulated dismissal, would allow that to happen. Upon briefing our response and looking at those details in issue from the responsive side, it rose questions to us in a greater detail of how a case that has been dismissed with prejudice by stipulation, and that order not being asked to be set aside or any rationale to be set aside, could be ripe for an appeal. So if this court does find jurisdiction in the matter, it should affirm the lower court's decision, both in its determination of how the law should apply and in the dismissal of the case. The Court of Appeals in the Steamboat Springs case, has already determined how the Clifton sanitation case should be read. And it is unreasonable to look at the facts of this case and find that it is more similar to Clifton than it is to the Steamboat Springs case.
Well, counsel, Steamboat Springs is a Court of Appeals case. Clifton is a Supreme Court case. We're bound by the Supreme Court case. We're not bound by the Colorado Court of Appeals case. Would you agree with that?
I agree with that.
Okay, so we're not bound by anything said in Johnson, regardless of the subject.
No.
Okay, and wasn't what was said in Johnson about Smith pure dictum because the parties had stipulated that it was a compensable interest and they were simply arguing over value?
I believe the court in Johnson squarely addressed the nature and definition of the interest that's involved. They separated that from the discussion of the value and addressed, in particular, what was the value that was involved, the property interest that was involved, excuse me. And in determining what that property interest was, it recognized that the interest was connected to ownership of the land, that it benefited the property owner, it burdened the subject land, and that it passed with title. Basically, that it was an appurtenant property interest. And it recognized that it didn't matter whether that appurtenant property interest was positive or negative. And in particular, it was a negative covenant, a negative easement, which the court in Johnson equated as the same and which are the same, and recognized that a negative easement or a restrictive covenant was indeed possible to be a compensable interest. It recognized in that discussion Smith's holding, and I believe specifically recognized the underlying issues that were related to Smith, which is this scheme, this plot of the landowners after initiation of condemnation to try to thwart it. And that's just not present here. Therefore, there's nothing in Smith that justifies setting aside the fundamental concept that when a condemning authority wants to require a property interest, it has to pay just compensation for it.
Counsel, in Smith, the court announced a broad rule, and in so announcing, didn't mention the scheme aspect. And secondly, gave policy reasons for the rule that have nothing to do with the scheme aspect, but would apply in any case in which there is this kind of covenant. How do we get around that?
Again, the Court of Appeals in Johnson was looking at the same Smith case. I think, respectfully, that overstates what Smith accomplished. Smith states specifically, it requires no imagination to determine why the restrictive covenants were executed and recorded on the eve of filing of the condemnation case. And this is on page 119 of the decision. This plan was devised to circumvent, if possible, the plans of the petitioner in the condemnation case. And then it says, we are of the opinion that such a scheme as this one, this plot to circumvent the decision, is contrary to the sound policy and invalid against the constitutional rights of the condemner.
And the court could have stopped there. That could have been the basis for the decision, but it didn't stop there. It went on to pronounce a broad rule with broad policy reasons, citing cases that aren't similar to Clifton in terms of a scheme. And how do we ignore all of that? I mean, we're bound by the decision.
Because I still think the facts of the decision are based, or the holding of the decision is based on the facts that are presented before it.
But I'm troubled by that notion because the policy reasons don't have anything to do with those facts, okay? The policy reasons the court gave would apply in any case, including this one, in which you have this kind of restrictive covenant. So how can we say it's limited to the facts? I mean, we have all cases involve certain facts. okay? But sometimes courts announce broad rules in those cases, particularly in Supreme Court cases. And we don't say, well, the car was blue in that case instead of red. I mean, we look at the rule. We look at the policy reasons given by the rule. And if they apply in this case, I think we have to apply them.
Briefly, I think that means a decision along those lines couldn't possibly be read in accord with Steamboat Springs case, which has indicated how Clifton should be read. And I also want to note very briefly one other distinction. In the Clifton case, the court noted that the Clifton Sanitation District was a stranger to the restrictive covenants. And here, when the town of Monument bought Lot 6 in the development, they became a party to, subject to, and bound by the restrictive covenants that they are now trying to set aside. And that is a situation that is entirely different from the Clifton scenario and should not justify them to allow them to acquire a property interest from property owners without paying just compensation for it.
Thank you. And Mr. Rivera, you have, looks like 2.5 minutes.
Your Honor, if the panel has no further questions for me, I'm willing to forfeit that time.
It's up to you. Thank you. That concludes oral arguments then. Thank you to both counsel. We will issue an opinion in due course, and now we are in recess.